we have the utmost respect for your honor, your courts, all the parties, half the attorneys in this case, I know, to safeguard against this ever happening again.
Okay, it's 8:30, so let's call the case. Okay, can we go back on the record? We'll call the case. It's 8:30.
Yes.
Okay, it being 8:30, which is the time set for the hearing, we are going to call, and this is pages 1 through 16, Richt, R-I-C-H-T, versus AffinityLifestyles.com, Inc., 831880, which is coordinated for discovery with other cases. So at this juncture, I'm going to have everyone make their appearance. Before we do that, though, when you make your appearance, if you're on audio-visually, please state the date that you filed your notice of audio-visual appearance in accordance with Supreme Court rule as reasserted and mentioned, or however you'd like to phrase it, as restated, reordered in Administrative Order 2207, filed April 29th, 2022. I'd also like to note, although everyone should have reviewed the docket, in this case we had a request for media. The court did sign that, and so on behalf of the party that did the media request, they had requested not only to observe, but also to record. So they are more than welcome to do so with regards to this hearing. And I'll just give you a quick heads up with regards to that. And the reason why the court only did it for this hearing, just so that you understand, is that since these are coordinated matters, not consolidated matters, I couldn't sign something that would impact some other hearing in another judge's department. So that's the reason why we did a little bit differently on this one, because the status of how this case is with being coordinated rather than consolidated, etc. So with that, we're going to go through appearances, please, on behalf of plaintiff, please.
Good morning, Your Honor. This is Brianna Switzler, bar number 15653. I filed the notice of intent August 31st.
I appreciate it. Thank you so much. Okay, Affinity Lifestyles, please.
This is Attorney David Spurlock, bar number 2565. We filed our remote appearance on 9/1/2022.
Okay, and
good morning, Your Honor. That was not counsel for Affinity.
Right.
This is John Odou on behalf of AffinityLifestyles.com, DBA Real Water LLC, and Real Water Inc. I filed my notice to appear via this format on August 29th.
I appreciate it.
I apologize, Your Honor. I misunderstood and I misheard.
No worries. Mr. Spurlock, you want to restate your appearance?
Yes, and for United Natural Foods, bar number 2565, we filed our remote appearance on 9/1/2022. Thank you, Your Honor.
Appreciate it. Milwaukee Instruments, please. Ms. Lowell?
Sorry, good morning, Your Honor.
Go ahead.
Elizabeth Lowell, bar number 8551 for Milwaukee.
Okay.
I filed my notice of intent to appear on 8/26.
Okay. Thank you. You sound like you're getting a little feedback, just to let you know, so you might want to check if you have a phone close to your computer. Is usually the thing, or sometimes if speakers are turned really, really high up, but we'll see. So
is that better? I just threw my phone across the room. Is it better now?
Is it better, Madam Court Reporter? Yeah, she says it's fine, and she's the one who's recording, so that's fine. Okay, Defendant Costco, please.
Morning, Your Honor. Michael Federico, bar number 5946. We filed for the order to show cause on August 29th, the AV request, and then July 27th for the two motions to associate counsel, Your Honor.
Appreciate it. Thank you. And then, do we have anybody else remotely on behalf of Costco, or just yourself?
Just myself.
No, remotely first. I was doing, oh, sorry. Okay, no, the reason I see another box. Okay, well, okay. And here in court, please.
Good morning, Your Honor. Noushan, Noureddini, admitted pro hoc vice on July 22nd, 2022.
Okay, we had two other people who had pending pro hoc vices. Are they not appearing today at all for their motions for pro hoc vice?
My local advised that they did not need to be here today because they're not attorneys appearing for the court.
They didn't need to be here for their motions? There are pending pro hoc vice motions. Counsel, is that a correct statement, Mr. Federico? Did you state that?
That's correct. It was our understanding that they did not need to be there because they are not counsel of record and that they could just listen in.
They didn't wish to provide any answers for the court with regards to their pending pro hoc vice applications?
Your Honor, they would have been happy to, but Mr. Federico told me that he had spoken with, I believe, someone in this, he told me that they did not need to be here and could not be here because they are not admitted in the case. I would be happy to get them here. That is, I apologize. That's what I was wanting to follow the court's, what I understood the court's rules to be, and not have a counsel that's not admitted appearing before you, Your Honor.
Okay, so today we had a couple of matters. Court will address that when we get to that. Thank you so much. We have first, let's do the order to show cause. And just for the order to show cause, the order to show cause, as you know, is with regards to the pro hoc vice individual on behalf of Costco. Anybody else is welcome still to attend, but from the court's understanding, there wasn't anything that addressed the rest of the parties. You're more than welcome to public courtroom. People are more than welcome to participate or to observe. But does anyone think that there was something else scheduled for today other than the order to show cause and then the two motions for pro hoc vice with regards to Costco? Okay, seems like we're all on the same page. I just want to make sure that there wasn't any confusion with regards to that. Okay, so let's look at the order to show cause. You received the order to show cause. Well, first off, the court noted that it was going to do one, and at the last hearing, you received a copy of the transcript, it looks like, and you also would have received the order to show cause actual order on 8/26 that was filed and served at 3:39 p.m. Since that time, we did receive, one moment please so I can get the correct document number. We received one response. That response is document 128 on 8/31/2022, and that was filed by Mr. Federico and to address some of the issues. I did not see anything filed by, and so I'm pronouncing your last name correctly. Can you pronounce it for me, please?
Noureddini.
Noureddini, okay.
My affidavit, Your Honor, was included with the submission that Mr. Federico, it was Exhibit B to that response.
Were you in Nevada at the time you signed that affidavit?
No, it's in California Notary.
The reason why the court was asking is, right, it says State of Nevada, County of Clark.
I took that form to mean that it was for a Nevada case. That was the form I was provided the affidavit to use, the template, but I was not in the state of Nevada when I had it signed.
Okay, well, this is your opportunity to explain. You can appreciate that there is concern about the compliance with Supreme Court Rule 42, and you had a copy of the transcript and the statements that you made therein, and you can appreciate the extent there may be differences between that and your affidavit. Why don't you explain to the court what's your viewpoint with regards to, this is the order to show cause, right? So this gives you the order to show cause why sanctions should not be issued up to including revocation of the pro hoc vice status for out-of-state counsel, detention sanctions for local counsel for the following reasons: failure to comply with Nevada Supreme Court Rule 42.2, failure to comply with Nevada Supreme Court Rule Part 9, and failure to comply with Administrative Order 22.7, despite the court filing and serving communications with instructions. So feel free. Are you going first or Mr. Federico? Who wishes to go first?
I probably should go first, Your Honor. This is Michael Federico speaking. I apologize.
Okay, go ahead, please.
Thank you, Your Honor. I've been practicing law here for 26 years, several titles. I don't have any discipline. I think this is a situation of mistake, inadvertence, unintentional, excusable, and that would have been my office, not Pro Hoc Vice's office. This all seems to stem from a June 9th, 2022 hearing that involved co-defendant United Natural. They were on apparently for a motion to extend time on that day, and also possible duplicates motion to associate counsel. Our client had no position in that matter. We didn't file anything for that matter. And my assistant, who's going through a lot, she did not have it on calendar for me. Hence, I did not have it on calendar. Out-of-state counsel would not have had either because she was not even admitted yet. At that hearing, you set the status check of August 20, 2022, the hearing that's issued today. And I understand you may have admonished the parties about following that Administrative Order 2207. Neither my assistant nor myself went and checked the minutes of the court from that hearing that didn't involve Costco to realize that Your Honor had set that status check. And that's us. That's on us, obviously. Didn't see if there was anything else going on. Normally in our one plaintiff, one defendant cases, we don't have anything else other than our client that we're dealing with. So really the only true actual notice, some kind of notice of that hearing would have been that email that was sent out the day before on August 24th, 2022, which my assistant would have opened but did not appreciate the content being noting a hearing less than 24 hours and just simply assumed it was something else that would be handled by out-of-state counsel. Again, that's on us, her belief that it was only discretionary for me to even have to appear once Pro Hoc Vice counsel was involved in the case. That's on us, obviously. I'm local counsel. You know, my staff know now that 42.14B notes that I shall be present at any and all hearings. That is handled now. That was an inadvertent mistake. Shouldn't have happened. Wouldn't happen again. And despite all of this, Your Honor, Pro Hoc Vice counsel did open and did look and appreciate that August 24th, 2022 memo noting the change in time for the August 25th, 2022 hearing. And yeah, while she did not properly follow 2207, she obviously had no time. And this all stems back from us not being at that me not being in that June 9th, 2022 hearing to find out that there was a status check set for August 25th, 2022. So I think with that, I think she showed her ability to be diligent and responsible and a practicing attorney here in the state of Nevada. Just to finish up with the August 25th issue, what happened was Your Honor started the hearing, found out local counsel, found local counsel, which is me, was not at that hearing. And apparently, out-of-state counsel, Pro Hoc Vice counsel's office, frantically tried to find me, who was not in the jurisdiction at the time. And we didn't know what the hearing was about. We had nothing on calendar, obviously, stemming back to our mistake from June 9th. I was able to find somebody that could cover. And of course, unfortunately, weren't able to comply with 2207 because me first actually knowing about the hearing was that date of the hearing when it was obviously partially over and Mr. Staberski did come in. I saw the transcript at the tail end. About 30 minutes into it, the new time. And it's my representation that it was merely an effort to mitigate the situation. The most important thing was to have somebody there to comply with rules and any orders. And obviously secondary was, well, we can't really say a whole lot, though, because we haven't complied with 2207. So that would have been our own sabotage, obviously, Your Honor. I have the utmost respect for the substantive law, all procedural law, all the judges. I've never been doubted on this respect before, Your Honor. We have the utmost respect for Your Honor, your courts, all the parties, half the attorneys in this case I know, to safeguard against this ever happening again. I am looking at all of the emails, and I am opening up all of the emails with any kind of times and dates for hearings to make sure to double check that everything gets on. In this case, of course, as well as other cases too. I'm not going to say our busyness and having too many files or a lot of clients is any excuse. Just a matter that we get a lot of emails, and sometimes we get in the habit of letting staff look at emails, and you don't necessarily look at the ones that have to do with the administration. And that's on me, Your Honor, and it's not going to happen again. And it isn't, because I open them all. I've worked with Pro Hoc Vice Counsel, the current one that's before Your Honor, who's traveled from California to be in front of you just to show her good faith, interest, desire to be a part of Nevada for this case. And they prepare a lot of the pleadings for me to review. They do an excellent job with that. They ask a lot of excellent questions. And the conversation did come up as far as when the Motions Associate Counsel were originally on a week or so ago. And it was my understanding through discussions with different people and people from the law firm I'm a part of that they wouldn't need to be there unless ordered. So if something needed, if you're inclined to keep Pro Hoc Vice Counsel on and not do anything else to us, and you want to hear from them, we would obviously have that arranged, because it was their original intention to show up. But with the current situation of the case, with what happened on August 25th, thought this was the proper way to proceed, Your Honor. With that, we respectfully request you find cause to not revoke Pro Hoc Vice status, or do anything else other than allow us to proceed on this matter. And we apologize for any kind of delay or inconvenience this has caused this court, your staff, or any counsel or parties that I'm colleagues with, Your Honor. And with that, I pass it over to Pro Hoc Vice Counsel.
May I be heard, Your Honor?
Oh, yeah, of course. Go ahead, please.
Thank you for giving me the opportunity to be heard, Your Honor. I want to reiterate to the court that I'm sincerely sorry for my failure to comply with Administrative Order 2207 and Nevada Supreme Court Rule 9, Part 9, BB, Rule 4, Subsection 5, by not ensuring that a notice of appearing by audiovisual means was filed on my behalf prior to the August 25th hearing. As I stated earlier, I was admitted to this matter on July 22nd. The August 25th hearing was my first appearance in any state court in the state of Nevada, and on this case, my failure to have this notice filed was unintentional. I did not find out about the hearing until August 24th, and my focus was ensuring attendance at that hearing. I did not intend any disrespect to this court and the rules that govern all attorneys practicing before it and those practicing before it. I apologize for taking the court's time as well as the time of the parties and others present. I understand and will follow the rules. I am grateful for the opportunity to practice before this court as out-of-state counsel on behalf of my client, and the past 2 weeks that have followed the August 25th hearing have weighed very heavily on me. I take what occurred very seriously and have put in place further safeguards from my office to ensure that something like this never happens again. Thank you for your time, Your Honor, and your consideration of the affidavit that I submitted in support of the order to show cause, which I'm happy to go into in further detail to the extent that the court wishes.
Does this order show cause with regards to this pending application? I did not see any other pleadings or anything else that was filed by anybody else. Does anybody else, on behalf of any of the other parties, set forth that you wish to state any position one way or another? I'm taking silence, meaning no, unless... Okay, I'm not hearing anybody else. Okay. So, counsel, I think there may be... Here's part of the challenge, is maybe another way to phrase that. I'm going to cite directly from Fulbrook versus Allstate, 131 Nevada 276, 2015 case, which in that case, right, it does specifically step forth. We remind counsel that it is his duty to log in to the electronic filing system and check notifications for his cases as often as is necessary to properly monitor his pending cases. That is a specific directive, regardless if people choose, and that's counsel. Remember, this is always counsel's directive. I have a wonderful team, but my team's not responsible for things that happen in the court. I, as the judge, I'm the judge. Counsel, it's your responsibilities under not only Supreme Court Rule 42, but also Supreme Court Rule 9, Parts A and B, and to comply with the administrative orders. I'm appreciative some people may rely on staff for certain things, but it is ultimately counsel's obligation. And if there was any lack of understanding, I just quoted directly from Justice Sada's opinion in Fulbrook versus Allstate, and that's 2015. You could also see that there's an ALS, which goes through actually all 50 states, okay? And that's not the only situation that is. And uniquely, or not, coincidentally or not, there's actually another case that addresses this issue. Nitz versus Olson, Cannon, Gromley, Angelo, and Staberski. 456 P3D 1077. We appreciate the defendant in that case, right? So ultimately, you all prevailed in the case in case you didn't know, but the issue Fulbrook was directly cited in some of the appellant's briefs because of the failure to follow up on things which resulted in an order to show cause in a different department or not here in providing responses. So that is the Supreme Court authority, some of the Supreme Court authority on the concept, but here's what we also have. I'm appreciative that you all are kind of focusing on one thing, but I think you're missing realistically the rest of this case. And here's part of the challenge. Part of the challenge is, first off, Supreme Court Rule 42 is clear on its face. Always has been. There's no new changes as far as local counsel's responsibilities to appear at all hearings, okay? I've been on the bench for 12 years. I was local counsel for my previous firm, variety of different times. Had to appear. The rules have been there for way more than a decade. So that part has always, well, say it's existed over decades, probably the more accurate way to say it. Well, I appreciate that there's kind of a concept of trying to start with the June hearing. There's a challenge in that because with that June hearing, as the court just cited from Fulbrook, right, you have the obligation to keep looking at the docket. If you choose not to appear at a hearing, you still have an obligation to be up to speed on what happened at that hearing, right, directly from the Supreme Court. But in this case, also, it is the attorney's obligations, and that would be from Pro Hoc Vice once you were admitted and you signed up for electronic service, right? Under the electronic service filing rules, it specifically requires parties to keep checking for electronic filing service aspects, right? Plus, you all would have received notice because the minutes of that hearing, due specifically from June 9th, right? The minutes of that hearing, specifically at the bottom, do say 8/25/2022, 9 a.m. status check, trial schedule / case conference report. So it's been readily available for, well, take June 9th to the August hearing, right? More than 2 months. And that means counsel never checked the record in those intervening 2 months, which you can appreciate in this particular case presents a chronological challenge and a substantive challenge because there were 2 other Pro Hoc Vice applications done in that intervening time. And in order to have done those Pro Hoc Vice applications, you would have had to go to the very Odyssey system that had the very minutes that put notice with regards to that status check hearing. Or you have the fact that, okay, and you can't say that staff filed things because remember these were filed under Rule 11, right, with names of local counsel and names of 2 people from Pro Hoc Vice counsel's firm. So they too have all been aware of this hearing, okay? In addition, well, I heard reference to try and say it was just one notice with regards to the 825 hearing. I'm not sure if you all had an opportunity to actually look at the record, because that wouldn't be correct, because you would have received two, okay? Right? And actually, let me step back a little bit chronologically. Even before the court's various notices, okay, with the memos, because you got two memos with the Rule 22, the Supreme Court Rule 9, and the reference to the administrative order, as well as the date and time of the hearing, right? Two different memos. And I'll go to those envelopes in just a second. But what you also had in the intervening time is the various councils, some of which are on remotely right now, filed documents of their own, whether they be notices of remote appearances, etc., which include, just randomly picked out one, Milwaukee Instruments, notice of intent to appear simultaneous for the status check on trial scheduling scheduled for August 25th, 2022 at 8:30 a.m. Those documents were also e-served to all parties according to the Odyssey records, right? And so whether counsel chose not to open them, you would have had multiple notices by those other audiovisual transmission requests, not only the date and time of the hearing, but also the fact that other parties were filing audiovisual transmission requests, okay? And in fact, if you go to the Odyssey file and serve envelope receipt, you would see, had Milwaukee's as one of them, Michael Federico was served on that. And then we also had, that shows not opened. And we also had youth counsel, Ms. Noureddini, also received that one from Milwaukee, as did a Carla Arroyo Montiel, as did a Cindy McCulloch from Olson Cannon. In addition, and that was just mentioning one of the audiovisual transmission, there's more than one, but I'm not going to take everyone's time and go through all of them. But what you also had from the court is you had two separate memos, okay? The first memo was and remember, the court doesn't have to send memos to give you all the blue jeans links and the information, because parties are affirmatively responsible for getting that information. But this department tries to assist parties, really make it abundantly clear and to assist you all. So we did send on 8/24/2022, 8:16 a.m., right? So that's more than 24 hours before the hearing. Once again, this was subject to remote appearance information for hearing scheduled on August 25th, 2022. It then says in bold, please review entire memo, double asterisks on either side. And then it also has that second paragraph that the court had referenced at the 825 hearing. In bold, note, please be advised that any hearing on or after May 30th, 2022 must comply with Administrative Order 22-7 and Nevada Supreme Court Rule Part 9, A and B, rules governing appearance by telephonic transmission equipment and rules governing appearance by simultaneous audiovisual transmission equipment. Current administrative orders and forms for audiovisual appearances may be found on the court's website. And then we gave you the website so that we actually gave you the actual link that you could do, so no one even had to look up a link. And then we put in parentheses, please see Administrative Order 22-7 and Supreme Court Rule Part 9, A and B to ensure full compliance. And that was all in bold. And that, as you can see, was the second paragraph in bold above the blue jeans information, so that people would have to read that before they'd have the blue jeans link. So once again, another reminder, even though, of course, people have to be familiar, it's mandatory under Supreme Court rule, mandatory under the administrative order, and then also we gave that. And that 8/16/824 memo, it was Noushan Noureddini, Barnes and Thornburg, opened at 8:18 a.m. Carla Arroyo Montiel, Barnes and Thornburg, it was served but chose not to open it. But remember, people have to open these because they're required to ensure that you have notice of everything and you have the affirmative obligation, not only your Pro Hoc Vice Council, but of course also because Pro Hoc Vice Council specifically says under Rule 42 that you're going to comply with all the rules in Nevada and the same disciplinary, and I'm paraphrasing, I'm not using the exact wording, but that we also show for Olson Cannon, Michael Federico, 8/24/11:53 a.m. It was opened. And then we show Cindy McCullough, Olson Cannon, opened 8/24 at 9:59 a.m. Okay, and those were Pacific Standard Time times. Then there was the second memo because I realized inadvertently that had been set for 9 a.m. and it was business court matters that should have been 8:30 like the rest of the hearings, and we didn't want people to be confused because all the other hearings we've done in this case and other similar type cases on these large scale, other than if there's a specific CMO that says something different, you've done 8:30. So then a second memo went out. That second memo just said from 9 a.m. to the 8:30 and explained that and put that in bold again, August 25th at 8 a.m. That second memo also was. Sir, whoever's not on mute, could you please mute yourself just because you cause interference, please? And the court speaking, we would appreciate it. Thank you so much. That one also, Noureddini, Barnes and Thorburg, 8/24/1205. Carla Arroyo Montiel, Barnes and Thorburg, served but decided not to open it. That one, Michael Federico, Olson Cannon, served but decided not to open it. Cindy McCullough, Olson Cannon, yes, and opened it on 8/24. Later on in the day. So there were not just one at the end of the day saying a change in time. There was the first memo. So I'm not sure if you all really looked at the Odyssey record because these were all filed as part of the Odyssey record and you would have had them and you could easily get the envelope information. So you had two notices, not just one of changing a time for the first time being aware of 8:25. You also had it in the minutes where there's your affirmative obligation, but you also filed your own motions for pro hoc vice, two of them in the intervening time. In order to, as I mentioned a moment ago, in order to have done that, you had to be on the Odyssey system in order to do the file insert. It's Odyssey file insert. When I say you, your respective law firms, whoever was the designated person, was still under the attorney. And realistically, that means the law firms, each of the respective law firms, had to sign agreements to comply with Rule 42 3 times, not just with yours, Ms. Noureddini, but with the two pending ones as well. And that would be just in this one case, right? But you also sought pro hoc vice admission for members of your firm in at least one other case before this department, and in other cases, all of which would all require. And it says doesn't it say affirmatively that you read Rule 42, that you're going to comply with it? And the local council signature also says you've read Rule 42 and you're going to comply with it all. And this isn't just a one-shot deal. This is multiple in front of this department in this specific case. That's not even taking into account the other two coordinated cases this court has. And one of them, we know from Ms. Coe, was also around the same time period because that's in the Hurwitz, and I'm mispronouncing the first name, but it's one of the coordinated cases. And therein really lies the challenge. Well, I appreciate on the flip side, the Olson Cannon firm has appeared in front of this department lots of times and never had an issue. With regards to the Olson Cannon firm has complied, been very diligent, didn't have an issue till these came up. Your firm, Ms. Noureddini, hasn't appeared in this department, so I don't have any background. This is the first time, and the first time is the first hearing. And for someone who just got admitted pro hoc vice with firm affirmations, right, affidavits under oath, right, penalty of perjury, that you're going to comply with all the rules, and we send not one, but two. So even in addition to the affirmative obligation that should have looked at it yourself and known it, there's two memos from the court sent to two different people in your firm, and those wouldn't have been the only ones because of some other motion practice. I'm not holding you all accountable for the other cases, but I was trying to see if this was, the very, very, very first time and there hadn't been anything. And I did note also in trying to research for this that the idea of knowing about the simultaneous appearance request in this specific case, there was, as counsel even noted in his appearance, that those were filed back in July for what was to be at that time the pro hoc vice hearings for two other members of your firm. And so there obviously was notice that you needed to comply because it was done back on July 12th, which kind of can go both ways, I guess. So herein lies from the issue from the court. I'm appreciative of the response from the affidavit. I'm appreciative of the fact that you took the time to be here to address this order to show cause. The court doesn't issue these lightly, but, you know, it's multiple issues. Is there an affirmation specifically here as an officer of the court? Start with you first, Mr. Federico, that there's going to be compliance and you're going to ensure that you are opening up communications from the court as you're required to do anyway, and the court doesn't really have to ask you that because the e-filing service rules require it anyway. Supreme Court rules require it. The oath, everything requires it before the court says it, and I'm not trying to be redundant. It's just, I understood from your statement that's future, this is not going to happen. Is that correct?
Absolutely correct.
Okay. Ms. Noureddini, what's your position as far as what's going to happen in the future?
This will never happen again, Your Honor. I understand what will never will fully comply.
So here's what the court's going to do. I have a couple of choices. I do think that the extent and issues, and when you look at this really historically, like I said, try to look back in the case to see maybe this was the very, very first appearance, but it wasn't, or that maybe you all didn't get notice, but you did get it multiple times, okay? And we even put in bold, okay, multiple things that we're required to do anyway. And the Supreme Court 42 is, there's not an exception. There's nothing there, and it's affirmative affidavit. So really the question becomes is should the court treat this as an educational opportunity that, I'll ask Mr. Federico first, that you wish to do a donation to whether it be a 501c3 or an entity that involves legal education. The reason why the court says or an entity that involves legal education is sometimes people, and this is not a requirement, but sometimes people want to donate the law library. The law library, technically, as you know, is county run. It's not a 501c3. So that's why I say, or other entity that's involved in legal education. The reason why sometimes people have told me that they'd prefer to do something like that is because really you're taking it as an educational opportunity. You're really assisting somebody who may not have the resources or funds to do it. In another case, somebody wanted to take a pro bono case because they thought that would give them an educational opportunity to assist somebody else to do that. Or do you wish the court to consider sanctions? What do you all wish? I'm going to ask you each which you wish, or some third option. The court's not limiting those to two options. It's just those are sometimes things that have come up in the past, and so I at least wanted to make you aware of it. So let me hear what each person wishes to do. Federico,
I may, Your Honor. Sorry.
Go ahead, please.
This is Michael Federico. Gladly donate to the law library.
It's not just specifically law library. That is an exception to 501c3. I mean, there's Legal Aid of Southern Nevada, there's Senior Law Project, there's Boyd Law School, there's Nevada Legal Services. I don't want to inadvertently miss a name, but there is a whole number of entities and organizations that do really good work to try and help those that are less fortunate from a legal education standpoint. I'm not limiting it to, because if you're asking to do a voluntary donation, then that would be to the organization of your choice, and it would need to be something legal related, just because if you're trying to do a educational opportunity type concept. So you understood I wasn't telling people, I don't tell people where, if they want to, I try and find out what is the best course of action, trying to take into account realistically Olson can, and it's the first time I've ever had an issue in 12 years. So I need to take that in, I definitely take that into account. So Mr. Federico, sorry, I need to give that little clarification, so if you wouldn't mind setting forth what your position is, please.
Yeah, now that I understand, yes, educational opportunity and to make a donation to an organization that's set to provide educational opportunities and otherwise in the law, such as like cap attorney program and things like that. Yes.
Okay, within 2 weeks, notice of compliance, please. Okay. And unfortunately, I do need to have people do their written notices of compliance because And I have to put those on a status check because unfortunately sometimes I've now come across, well, I'm not going to step forth that. I don't anticipate that'll be an issue. Ms. Noureddini, what's your position on what you wish to do? Because you've had an opportunity, you can say that you wish the court to make a determination just based on what you said and everything presented. Of course, not requiring anyone to do an educational opportunity. I'm realistically asking you what option you think the court should do, and I can take that into account. Go ahead.
I concur with Mr. Federico. I would be happy to make a donation. I can also, I know you didn't mention this, Your Honor, but anytime there's a court appearance in which I appear, I can appear in person. I'm happy to,
The Supreme Court, I appreciate that the Supreme Court rules do fully allow people to appear audio visually. You just need to follow the rule. Okay, and I'm a district court judge. I need to follow Supreme Court rules. I need to follow administrative orders. Okay, there's no one yet has shown me any exception where I don't. So you can appreciate I, as a district court judge, have my obligations to comply with and to ensure that the rules are complied with. So, okay, 2 weeks for you for educational opportunity. Does that meet your needs? Well, notice of compliance.
It's
Or the
a
state of
donation
Nevada, some educational opportunity.
under 501c.
501c3 or an entity that does legal education. It may not be a 501c3.
Okay.
You're probably not familiar. For example, there's certain entities that assist others. For example, the law library is one. Boyd Law School is not a 501c3, but they have various programs, okay,
Right.
which provide educational opportunities. So that's why the court phrases it in a kind of more broader sense, because I'm not telling people where to do it. It's realistically the idea is these are supposed to be move forward so that people understand we get compliance, the educational opportunity, and no one wants to really have issues addressed. Okay. So the court, in light of the response taking into account the totality of the circumstances with the assertions of officers of the court here in court or remotely, that this was just an issue, like I said, taking into account the full plethora of things, and that people will actually be looking at communications from the court. The court is going to vacate the order to show cause, but the court is going to do just a status check on our chambers. And we're just going to call it a compliance status check 2 weeks from today. Okay? That would take care of that matter. I shouldn't say, let me make sure. Is anyone that wish to be further heard at all, or does that conclude that matter? Mr. Federico, do you wish to be heard any further?
Not on that matter, Your Honor. Thank you.
Noureddini, do you wish to be heard further?
No, Your Honor.
Okay, so that concludes, like I said, court vacated for cause, the order show cause. So now we'll go to the next two things. I have a pro hoc vice application for Ms. Coe. So the challenge with not having her here is you can appreciate she's with your firm. I have the only situation this court currently has with your firm is a non-compliance issue. So I have heard what you said on your own behalf, but what information would the court have on behalf of other members of your firm to evaluate that? That's a very unique situation. I must have been, this is the first time this has happened in my 12 years on the bench. So what is your thoughts on what? Should I ask local counsel first, Mr. Federico, or should I ask you first how you wish to proceed? Or if you wish to proceed today?
Your Honor,
this is Mike. Go ahead, counsel.
Your Honor, I completely understand the court's position. If I'm wondering if a potential option is to continue the hearing, given that I was advised that our local counsel's belief was that Ms. Coe and Ms. Ola did not need to be here so that they can appear before you and answer any questions that you may have. They're my colleagues. They're both partners at my firm. I have no question in their ability to be counsel for Costco in this case. And but I understand, Your Honors, the predicament that you're in. And I think maybe if we could continue the hearing so that they could be present, or I'm happy to reach them now, if I could do so, but that could.
Sorry, go ahead. That's your turn.
Sorry, if we could maybe continue the hearing or take a recess to see if I can. I know they know that this is happening right now. they asked if they needed to be here. That this is not any. This is strictly what we thought the court wanted, and so.
Well, okay. If there's a request to continue the hearing, that is going to be fine from the court's standpoint, because realistically, this is a unique circumstance, okay? And since you're all the same firm, I don't have the basis that to say, you know what I mean? And I want to ensure that everyone has the same full and fair opportunity to set forth if they wish to say anything, okay? It's not a situation where I've already had one person appear from the firm. I have all the same information, right, and that I have full compliance, and so I have that as a scope of reference. Here, it's the first time your firm has applied in front of this court, to my knowledge, off the top of my head, other than the affinity cases, because Ms. Coe did apply in the Hurwitz, and what I'm saying, let's call these affinity coordinated cases. So I don't have a scope of reference. And I think in fairness to everyone, I should have a independent, full, fair scope of reference for each individual person. So the court's fine. Continuing this, people do not need to appear in person. They can appear remotely, but they just need to comply with Supreme Court rule as reminding everyone in administrative order how we'd like to phrase it. So would that meet you all's needs?
Yes, Your Honor.
Mr. Federico, would that meet your needs?
Yes, Your Honor.
Okay, so then what we're going to do is, because I also, in fairness, I can't have you stop and do it. My 9 o'clock.
Sure, I understand. I'm sorry, Your Honor.
They're here on a special setting for request for injunctive relief. In fairness to them, to keep them even longer waiting is really want to give everyone a full and fair opportunity to be heard. I also have to balance that, and I also don't want to put the other two individuals on the spot without having some opportunity to look or prepare however they may wish to look or prepare, or maybe they've determined that they don't wish to, but at least I think they have to be asked. And then if they wish to. Here, like I said. So, what you're going to need to do is renotice the hearing, so that way you are picking when you think it's appropriate that you wish to do so, and that way you can ensure that everyone has a full and fair opportunity. They are intending on appearing, and that way everyone gets notice and everyone gets taken care of. Does that meet your needs? Do you file a new amended notice of hearing?
Yes,
However
we'll do
you're
so,
wishing
Your
to
Honor.
do it?
Yes, we will.
Okay. Mr. Federico, does that meet your needs as well?
Yes, Your Honor.
That would then conclude if those are being continued. So what we're going to do for right now is we're going to leave them on today's date is probably the easiest until we get a new motion. So what you're going to see is you're just going to still see them on today's date, because otherwise the clerk, we can take them off and vacate them if you're planning on refiling, or we can leave them on today's date and then they could be moved after the refiling, which is easier from a clerk's standpoint, which is more appropriate from a clerk's standpoint.
I didn't know if they refile it, so they could vacate it.
Okay. So what informed is it'd be easier to vacate it, and then when you refile, you get a new clerk's notice of hearing. That way everyone will get their appropriate notices, okay? Does that meet your needs?
Yes. To clarify, Your Honor, is it just an amended notice for a hearing date, or do you want the motion refiled as a whole?
Feel free to check with your counsel about what is required here in the state of Nevada. Okay? Court can't provide legal advice. It's not the court's request, it's what's
Sure, I
required to
understand,
do
Your
so.
Honor.
So, since I have other counsel for the right matter, I didn't show, like I said, that there was anything else on for today. Does anyone else need anything addressed that would be appropriate to address? Or shall I just wish you all a great rest of your day and weekend? I'm not hearing anybody speaking. It doesn't look like anyone's mouths are moving, and one person is no longer on audio visual. So it looks to me that I'm going to say have a great rest of your day and weekend, and we will see you at the next hearing in this case, which, as you all know, you have a status check regarding the case management order and trial setting set for October 13th, 2022 at 8:30 a.m. Available right there on the listing in Odyssey, and it was set at the last hearing. I do appreciate it. Thank you so very much, and we're going to move on to our next matter.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you, Your Honor.